Welcome to this week's OK at Work with myself, Sarah Sawyer, my colleague, Russell Berger, both business attorneys at Offit Kurman. And this week we are talking about settlement agreements. So lots of litigation happens, litigation gets filed, demand letters get written, just thousands of them and thousands of them, millions of them probably a year. However, most business owners are more likely to find themselves in a settlement position than going all the way through litigation, all the way to a jury or a judge and an ultimate finding of fact. Just based on the cost of litigation, both the time and the money, and just the motivations for both parties to settle. So we see settlement agreements come across our desk probably almost every day. And in the employment context, there's definitely some important nuance to making sure that you're properly releasing all claims when working through a settlement agreement. What are some things that employers need to consider, Russell?
Yeah, and I would say this applies to severance agreements as well. Even if there's no litigation and you're just trying to buy your piece when an employee exits, these same principles apply. And I think there's a couple of things that really stand out in the employment context. Number one is the federal wage law, the Fair Labor Standards Act, has a provision in it that says you can't contract out of it. And that's been interpreted by a lot of courts to mean that you can't get a release. And a release is really what you want as the employer. You're paying money and the former employee is giving you a release, not going to sue you, releasing all their claims against you. But an FLSA claim can't be released without court approval or without Department of Justice approval, which, in a lot of context, if you're not in a litigation, you're not going to file a lawsuit to get in court and get approval. So there's ways to deal with that. And if you are in court, you have to go through the process of getting court approval. Additionally, one of the other things that we see a lot of is with the Age Discrimination and Employment Act. That has very specific process that you have to follow. You can get a release, but generally speaking, you have to provide at least 21 days for the employee to review the release language. And then once they sign it, they get 7 days to rescind. And so that leads to different strategies for how you handle that. Sometimes you might parcel out a portion of the payment to go to that specifically, and the rest of the release is valid immediately. Sometimes you just lump it all together, and you don't pay any money until that effective date, until you've gotten more than 7 days after the date of signing, so that there's no chance of rescission. So there's different strategies to consider with that. In addition, if it's more than one person being laid off as part of kind of a reduction in force or another form of mass layoff, you have to provide more information, and that 21 days goes to 45 days. So again, these are just all things that no business owner necessarily has to be an expert in these things, but it just kind of highlights the fact that you really need to be conscious when you're entering a settlement agreement or any kind of severance agreement with an employee that there are moving parts, and it's not as simple as just, I'll pay you X, you release your claims, we'll go our separate ways.
Yeah, and another thing with the severance agreement that I've seen come up is making sure that the consideration is proper for the release as well. The last thing you want is to invalidate a release by offering them something that they're already entitled to. So if they're already under your policies entitled to vacation time, or they're already entitled to certain types of compensation, and you tie the release to that, as consideration for the release, then if that's the only consideration, then you definitely haven't, you don't have a valid release. If it's part of the consideration, there's some arguments there about whether that, the consideration is going to support the release. So we really want to make sure that they're clean, because you don't want to be thinking, especially if you think there is risk there, because a lot of times severance agreements are a way to manage and mitigate risk that might really be present based on certain facts and circumstances. So I want to make sure that it's really buttoned up and that you are actually getting a full release of those claims and really mitigating the risk. If you're going to pay for it, you want to make sure you've got the release locked up.
Yeah, absolutely. And the other point I wanted to make is that when you sign a settlement agreement or a severance agreement with an employee, you got to be careful about any pre-existing agreements and whether they carry over or not. So, for example, and we've talked about it a bunch on here, you have a non-compete, a non-solicit, confidentiality, some kind of restrictive covenant agreement that's already in place, and maybe you don't want that to go away. You want to pay someone money, you want them to release their claims against you, but you want these restrictions to continue. You got to address. I think it makes sense to directly address that in a settlement agreement or a severance agreement. I don't think you want to leave it to chance as to whether it was supposed to continue on or not, because most of the times when lawyers draft contracts, you say this is it, this is the totality of the agreement, and it wipes out everything that came before. So you want to be really conscious about what steps you take to address that as well.
Yeah, and just in closing, I mean, it can also be an opportunity to beef up some of those provisions to the extent that, they're not as thorough as you might want them to be. You can also look to potentially use the severance as consideration to make those changes as well, or include language that you didn't put into an employment agreement or other agreement that you had meant to. So something to consider there as well. Well, thank you, Russell, and we'll see you next time.
Thanks, Sarah.